Hello, my name is Bill Tingley, and on behalf of the Jefferson County Family Court Judges and the Jefferson County Family Court Advisory Committee, welcome to Inside Family Court. This program is designed to take you inside the family court courtroom and give you a better understanding of what goes on there and why. The creation of family courts represents a major change in the law, both in terms of what the law is and how it's enforced. In April of 1991, Jefferson County joined a growing number of courts across the nation which changed to the family court concept. When we started in 1991, the family courts had 6 judges who handled a limited number of cases. Today, we have 9 judges, each of whom handle over 2,000 new case filings per year, in addition to other case management responsibilities. Our family court is nationally recognized. Every month we have judges and court administrators in from as far away as Hawaii and as close as Frankfurt watching our family courts to see how they should set up their own. Though controversial at times, this truly is an exciting project for our community and one that we can all be proud of. So please stay tuned for this edition of Inside Family Court. My guests this week are Judge Jerry Bowles, who came onto the family court bench in 1996 from the County Attorney's Office. Judge Bowles was one of the architects of Kentucky's domestic violence statutes. Judge Mason Trenaman has been a family court judge since 1996. Formerly, Judge Trenaman was an assistant Commonwealth's attorney and assistant county attorney. He has been a proponent of economic fairness for women and fathers' rights issues. Judge James Michael Green has been a family court judge since 1992. In addition to his duties as judge, he presides over the Juvenile Drug Court Project. Judges, thank you for being here. As you know, our topic today is what is family court? Judge Green, would you give us a good working definition to start with, please?
Well, the concept of family court, Bill, is one family, one judge, which is supposed to lead to more consistency and uniform decisions regarding families.
All right, and is this a change from what we were doing before?
Oh yeah, very much. It's a drastic change because we have several different areas of the law that we deal with in family court that used to be addressed in various courts in various parts of the building.
Judge Trenaman, take us back to pre-1991. Extrapolate a little bit on what Judge Green had just said. What were we doing that was different than what we're doing now?
The first thing to remember is that when families are going through the divorce process or issues they have in family court, they're very seldom isolated instances. Quite often families who are going through divorce are going through the toughest times of their lives. It's not uncommon that during those times we have other problems. Divorce essentially means dividing up the property, deciding monetary issues. In addition, you've got custody issues that would be in the divorce case. But oftentimes families also have other issues, domestic violence for instance, children who are beyond their parents' control, perhaps kids who are dependent, neglected, or abused by their parents. In the old system, with the district court, circuit court breakdown, you could have literally 4 or 5 different judges at different district and circuit court levels hearing about this family's problems 4 or 5 days in a row, having the family come to different courtrooms, different days, for different piecemeal solutions to their problems. Family court lets us look at their problems as a big picture and try to come up with solutions that are going to work for the entirety of their problems, not merely one piece at a time.
Judge Bowles, Judge Trenaman's touched on it. Tell us what kind of cases pre-1991 were being heard down in the district court and what kind of cases were being heard up in circuit court. That is, what are the bulk of the cases that the family court now hears?
Okay, the district court cases that were heard prior to the conception of family court were abuse and neglect cases where the cabinet has sought removal of children based on abuse or neglect, domestic violence petitions where a partner in a relationship is being abused and comes to the court to seek protective orders, paternity cases where parties have never been married but they've had a child together, and status cases, cases involving teenagers where a child is beyond a parent's control, not attending school, habitual runaway. The circuit court was hearing divorce cases, domestic relations cases, adoptions, termination of parental rights, and those cases are so closely interwoven that often when the circuit court was hearing that divorce case and deciding custody and visitation issues, they didn't have relevant information that had already been heard by district judges in a domestic violence or a dependency action.
Okay, so the solution was to get all those, group those kind of cases together and get them heard by the same judge. Is that what I'm understanding?
Yes. The way family court is set up today, we have an alphabetical rotation, which means that if your last name ends in A, B, or C, whether you're here for custody, whether you're here for domestic violence protection, any of the issues we hear would be before that one judge. So there are 9 divisions, and we each have 1/9 of this community's family issues.
All right. Now, Judge Green, I know that Judge Bowles and Judge Trenaman are circuit court judges. You're a district court judge. How is it that a district court judge is hearing cases that were traditionally circuit court cases, and how is it that I've got circuit court judges now hearing district court type cases?
It's quite easy, really. I am appointed a special circuit court judge to handle the circuit court matters that come before me. They are appointed special district court judges to handle the district court matters that come before them. And these folks got elected as family court judges, whereas I'm a volunteer basically from district court, and there have been several district court judges who've come into the family court system and gone, several who've stayed, Judge Fitzgerald, Judge Corey.
One family, one judge, alphabetical selection of the client. Is there ever a situation develop where the alphabet changes? Judge Trenaman?
Sure. There are often times where the alphabet is different. Maybe mother and father were divorced 5 years ago, and mom has now remarried, or mom took her pre-married name back. We have families who have children with different fathers who have different last names. For that reason, it's not uncommon that on an initial case call, whether it's a dependency, abuse, and neglect action or a divorce case, that the folks are in a courtroom that hasn't heard the past cases. At that point, the judges attempt to determine what courtroom heard your prior cases. Does it make sense for this case to go to that prior courtroom so that we can have all of those actions heard at the same time by the same judge? If in fact it makes sense for that to occur because the old divorce action didn't just go away, then we will get those cases together so that the same judge will hear all of the family's problems. If the case was 10 years old and the original judge was gone, it may not make sense to transfer back to that division. But we always, always, always want to have all active cases in front of the same judge.
Judge Green, have we solved the problem? It sounds like what we had was some overlap that we've solved by putting together this family court system. Has that solved the problem? Are we getting more continuity in our decisions?
Absolutely, I think we are. And I think that we have a lot of communication among the courts that other courts don't have. I agree with Judge Trenaman, because we'll have a family of 5 children and each child has a different name, and mom's got a different name and dad's got a different name, and so depending on who was the victim or who was the prosecuting witness or whatever initially brings it to family court, whatever the indicator is, you're going to go to a bunch of different courts. Also, because district court cases, many district court cases have time limitations. Something has to happen within 72 hours. Something has to happen within 10 days. You have to be able to hear another court's case on an emergency basis. And we have actually broken down the emergencies among the 9 family courts, and we share the burden, and everybody takes their share of emergencies.
Very good. Judge Bowles, is that the end of the story? We had an overlap of types of cases that were handled. We solved it by putting together a family court system. Is that the beginning of the end? Can we go home?
I think it's probably the beginning rather than the end. We handle a tremendous volume of cases. Each division has over 2,000 cases of new filed cases each year. Even though we have one family, one judge, it's impossible for us to remember everything about every family member and every incident involving that family. As a result, we have a staff support system that we work with. Each of the 9 divisions has a court support worker that works with that court. We each have a liaison from the Cabinet for Families and Children's who works in the dependency cases and the status cases, the dependency cases being where the child may be at risk of abuse or neglect, and there's an action to remove that child or to provide some safety net for that child. Status cases I talked about earlier, the teenage cases. We have staff attorneys who work with us, help us to do research, and so there's an entire complement of staff that works with the judges to help us to keep that information that we're constantly receiving regarding these families together so that we, as Judge Green said, try to produce some type of uniform outcome for that family.
And this is unique to the family court?
Yes, it is very unique.
Concept.
As a matter of fact, family court here in Louisville is a model program recognized nationally. There's about 4 nationally recognized family court systems, with Louisville being one of them.
Judge Trenaman, what about outcomes? Is there a difference in how the outcome might manifest itself in family court now versus before there was a family court?
The biggest difference in the, quote, outcome itself is simply that one judge is issuing consistent opinions with respect to all of the family's problems. As we've talked about before, or let me say symptoms rather than problems. You have the family. Within that family, you have problems. You have a symptom that is the kid beyond control. You have a symptom that is dad hitting the child and leaving bruises. You have the symptom of child support and property division. Before, with different judges hearing them, you could have inconsistent decisions. With one judge hearing everything, the decisions are consistent with respect to the opinions and the outcomes. The outcomes themselves are consistent is number one. But number two, what we found in family court is that by specializing in these cases, by handling the cases in the family court, families are getting into the court system and out of the court system faster and in a more expedient fashion. You can get your case heard with respect to an abused child much faster today than you could have in the past. If you need a divorce trial, you get your divorce trial much faster today in family court than you ever did previously in the circuit court. Specializing in the family court has allowed that to occur. Your divorce case, your child custody case, will not get bumped because you have a robber on your docket that day, will not get bumped because of an automobile accident case. The family cases are treated as important because they are extremely important and a major, major part of our society, and now they get handled in a much more expedient fashion. You get through the system faster.
Judge Green, let's take a specific scenario. Let's assume that a person appears before you in a dependency, abuse, and neglect case. There's an infant child. There's a mother who's drug addicted. She's being alleged that she's mistreated the child as well. Let's say, for this example, the father's out of the picture. What kind of remedies can you give as court orders that perhaps you couldn't have or wouldn't have been able to prior to the family court?
Well, to address the substance abuse problem, one of the orders would be she would be ordered to have a substance abuse evaluation and follow up with any treatment recommendations. But that, in all likelihood, wouldn't be all of it. There might be an anger issue. She might be ordered to do some anger management. There might be parenting issues, maybe some parenting classes. So nothing's really as simple as it seems. It's not take 2 aspirin and call me in the morning. If it were a different type of case, and I'm sorry, I wanted to explain to you that the Cabinet for Families and Children would be involved with that case, would be watching that the mother did what we asked her to do, and would be giving us a report when they came back to court. If she broke down before court, they may file a motion to get it back into court sooner. If it were a different kind of case, like a domestic violence case, we've now created the Court Monitoring Center, where the person who's ordered to have anger control or substance abuse evaluation and treatment goes to this center and registers with them, and they monitor the case, and the Court Monitoring Center notifies us if they get out of compliance.
All right. Judges, we're going to need to take a short break right now. Thanks, and we'll be back in a minute. Welcome back to Inside Family Court. Our guests are Judges Green, Trenaman, and Bowles. Judge Trenaman, before we left off for the break, we were talking about the social service aspect of what we do as part of family court. And we all know that there's been some criticism that we've turned our judges into social workers. How would you respond to that criticism?
I would respond essentially that it's simply not true. I am not a social worker. I am a judge. I hear facts, I hear testimony, I see evidence, and I make decisions. Based on those decisions, I will enter certain orders. Those orders may well involve the use of social service agencies. What family court allows us to do is to have a repository or a location where those social service agencies can come together. If I have a family in front of me and dad needs anger control counseling, mom needs alcohol or drug abuse counseling, the children need some help with an individual educational assessment at the Jefferson County Public School System, I have those agencies that can come to my courtroom through contact with the court and provide those services for the family. I myself, as judge, as the trier of facts, do not provide those services. I'm not a social worker, I'm not a counselor, but family court does make those services available to the family. So I think the criticism that judges are social workers is not an accurate criticism. And do I think that bringing those services together and providing those for the family in one place so they don't have to run all over town looking for these social service agencies is a good idea? Yes, I think it's a wonderful idea and a great service that we as the family court can provide to the citizens of our community.
Judge Bowles, there's also been some criticism that families who don't have children aren't moving as quickly through the system or are getting put on a back burner when family cases involving children are before the court. How would you respond to that criticism?
I think that criticism may be somewhat true. However, family court deals with a number of families in crisis, and it's important when that crisis involves small children that where safety issues are of concern, access to children by parties that are before the court to maintain some status quo for that child are important. So they may at times get priority over that husband and wife who's coming in for a divorce and they need their pensions divided or they need their stock plans divided. And I still think that statistics would show that all actions, including those parties who don't have children, are being adjudicated much quicker than they were when there was the priority of, as Judge Trenaman said, criminal cases, right, or personal injury cases. They're all family court cases, and I think that statistically they're all being resolved with much more efficiency than they were prior to family court.
Judge Green, what would you say to the taxpayer who probably will never see the inside of the family court and who may feel like, you know, boy, here's just another instance of government expanding and simple things being made more complicated?
I'd tell them I'm a taxpayer and I see the inside of family court all the time and I feel like my money's well spent. I think people are getting, and this sort of touches on what the other two have just recently told you, people are actually getting help and getting their cases resolved much quicker than they did before family court came along. And circuit court historically has said that family court cases, just the divorces, was 45% of their caseload. And they would say that it was the worst of their caseload. And yet I can remember 15, 16 years ago, you go get a trial date in a divorce and it might be 2 years down the line. Now, we work hard to be sure that we're not going more than 4 months down the line to get you your trial. So I think from that standpoint, we're more efficient, we're getting done sooner, but our outcomes are better as well because we have this one-stop shopping. We do a little triage, if you will. We do a little diagnosis at the start, find out what does this family need, give them the services right then, let them work on their problems, and hopefully they come back fewer times.
And are we tracking that? Are we tracking the return?
There are actually timelines that were put into effect voluntarily by the family court judges as part of the new Jefferson family court rules that require us to make a good faith effort to have events happen in cases in a timeline that will lead toward an adjudication within 4 months, 6 months, 12 months, depending on the types of cases. Unlike, as Judge Green was saying, when these cases traveled through circuit court or the prior district courts, it could take years for resolution for these families.
And there was no follow-up.
Correct.
When you asked the original question, Bill, you asked what would the taxpayer, the citizen, think about family court? Aren't you just building in more bureaucracy? Let's take it out of the family court situation. Let's look at another series or system of problems that a family has. Let's say their automobile needs a new tire, needs a front end alignment, needs an oil change, and needs new windshield wipers. Does it make more sense to take that car to one garage and do all 4 things, assuming that the output, the actual work product, is going to be just as good? Or does it make sense to take that car, to take that family with problems to 4 different places on 4 different days and repeat 4 different times, here is what is wrong with our family? From just a logical, common sense standpoint, it makes more sense that way. Another thing I would tell taxpayer citizen, yes, we're getting through with your family cases in a more expedient, a faster fashion. What does that mean to the other cases? Criminal cases never get bumped for a child abuse case. Criminal cases never get bumped for a divorce case. You will never have a medical malpractice case that can't go to trial because the court is tied up dealing with, quote, children's issues, because a specialized court, the family court, will be handling those issues. So it's better for the family court system, it's better for the district court system, it's better for the circuit court system. The taxpayer, the citizen, is getting a better return in all 3 courts because of the creation of family court.
Judge Bowles, watching right now are a lot of people who are in the family court system, whether it's because of a divorce action or because of domestic violence or because of emergency protective orders. What would you say to them?
I guess overall I would say that the justice that's being delivered here at the Judicial Center in family court cases is a fairer product, because we now have judges where these types of cases are their passion. And they may not agree with the disposition in their cases, but I believe that they will not leave here feeling like this judge didn't care about their problems, their family, their issues. That it was a judge that heard their case, that understood family dynamics, and that individual and that family was important to them. And I honestly believe that if we allow litigants to leave with their dignity intact, feeling like they've been heard, it's not so much what we decide, but it's important for them to feel like they've been heard. And as a result, they're more likely to follow our orders.
Judge Trenaman, what would you say?
I don't think there's much follow-up on that. The families, when they are in family court, realize that their cases are important. Sometimes, historically, if there was say an abuse case, for instance, and in the district court, that judge may have had 30 cases to hear that day. And it is really easy on district court days to get that, move them in, move them out, the line up and do the cattle call. We as a family court want to hear these cases. We don't have anything on our docket that's more important. We want to hear those cases, let the families know it's important to us. The divorce litigant doesn't show up thinking that the judge is going to enter a finding on a very important custody decision only to be told, go away. I've got a criminal case that's more important than your family. Go away. This automobile accident case is more important than your family. They're made to know, whether they agree with us or not, that they had their day in court, that we cared about them and their problems, and that we made the decision we thought was best and most fair for that family.
Judge Green, have we thrown the law book out the window?
No, obviously we haven't thrown the law book out the window. If you come in here quite often citing those law books. There are several lawyers that practice this type of law and cite those law books. But we've added something to it. We've added a dimension to it. We put human beings in it.
Judge Green, Judge Trenaman, Judge Bowles, thank you for being with us today.
Thank you for having us.
Thank you.